Your landlord is counting on you not knowing this one law. And if you don't, they keep your money, legally, even if you left the place spotless. Here's a quick caveat before we go further. The exact deadline changes by state, but the basic rule is consistent almost everywhere. Normal wear and tear is not your bill. Not probably, not usually, not in most cases, it is never your bill. That's not a loophole, that's the law. And here's what your landlord is hoping you skip. Your lease might say otherwise. It might say professional cleaning required, or carpets must be replaced upon move-out, or property must be returned in original condition. Signed, dated, your name on it. Your landlord is betting you think that signature is final. It isn't. State law overrides your lease, almost everywhere. That's the secret. And once you understand it, you'll never look at a security deposit the same way again. Let's go back to the beginning, because the story starts before you even hand over the keys. You found an apartment, signed the lease. Maybe you did a move-in walkthrough, noted a scuff on the wall, a carpet that had seen better days, a bathroom door that stuck. Maybe you didn't. Either way, you paid a security deposit, 1 month's rent, maybe 2. Let's say it's $1,500. That's real money. And right now, your landlord is holding it. In some cities, that number is closer to $3,000 or $4,000, sitting in an account you have no visibility into. Fast forward, you're moving out. You've cleaned the place, vacuumed, wiped down the counters, scrubbed the bathroom. You think you're fine. Then the letter comes. And they sent you a very official-looking piece of paper to make it feel legitimate. Here's the thing. They might have just broken the law. So what actually counts as wear and tear? Think of your apartment like a rental car. You drive it for 3 years. The tires wear down. The seats show creases. The floor mats get dirty. None of that is damage. That's just what happens when something is used normally. You don't owe the rental company new tires because tires wear out. That's built into the deal. Your apartment works the same way. Carpet that's flattened and dull after 2 or 3 years of normal use, wear and tear. Nail holes from hanging pictures, wear and tear in most states. Small scuffs on walls from furniture, wear and tear. A door handle that's loose from 3 years of being turned, wear and tear. Paint that's faded or slightly discolored after several years of normal light and air exposure, also wear and tear. Landlords are generally expected to repaint every few years as a cost of doing business, not charge you for it on the way out. But here's where the lease loses power. Carpet with a pet stain soaked through to the padding, damage. A hole in the drywall, damage. A broken window, damage. Mold because you never reported a leak. Depending on your state, probably damage. The test isn't whether something looks bad. The test is, did this happen from normal everyday use, or did someone cause it? Normal use, you don't pay. Someone caused it, you might. Your landlord knows this distinction. The deduction only works if you treat the invoice like a final decision. Now, here's the part that genuinely sounds made up, and this is where the strategy starts to unravel. Many states have laws that void specific lease clauses about cleaning and restoration. Flat out void. Your landlord put it in the lease. You signed it. A court would throw it out entirely because the clause itself is illegal. California is the famous example. You cannot legally require a tenant to pay for professional cleaning as a standard move-out condition. It has to be actual damage beyond normal use. Full stop. Other states like Washington and Oregon have similar tenant protective frameworks that limit what landlords can contractually require. So that $350 carpet cleaning fee? In some states, your landlord knew, or should have known, they couldn't legally charge you for it. They sent the bill anyway. Completely legal to send. Very illegal to keep if you push back correctly. That's the con. It's not aggressive. It's not threatening. It's just a letter. And it works 9 times out of 10 because tenants don't push back. They're already stressed from moving. They assume the paperwork is real. So what do you actually do? First, know your state's deadline for deposit returns. The deadline may matter more than the damage. California gives landlords 21 days. New York, 14 days. Texas, 30 days. Miss that window, and in many states, your landlord forfeits the right to keep any deductions at all. Some states go further. They owe you double or triple, not because you complained loudly, because a clock ran out and they missed it. Second, if deductions are taken, your landlord must send an itemized list, not a vague email. not a phone call. An itemized, written breakdown with actual receipts. Cleaning, $200, with no documentation isn't sufficient in most states. No proof of what they spent. They may not be entitled to keep it. A receipt from a cleaning company dated after your move-out and matching the amount claimed. That's the standard. A number on a page doesn't cut it. Third, and this is the move most people skip, send a written demand letter. Here's what that letter basically says in plain English. I got your deduction notice. Under my state's tenant protection law, landlords can only deduct for actual damage beyond normal wear and tear. The items you listed don't meet that standard. I'm requesting back within state deadline. If I don't hear from you, I'm filing in small claims court. Your state may award me 2 or 3 times what you're withholding. Most landlords settle immediately. Small claims court costs under $100 to file in most states. The penalty for wrongfully withholding a deposit can be 2 or 3 times the withheld amount plus attorney's fees. Their lawyer isn't working for free. The math stops working in their favor real fast. This is exactly the moment your landlord was hoping to avoid. They were betting the official-looking letter would end the conversation. They counted on you taking the $550 and moving on. They have done this before. They will do it again. To someone who doesn't know what you now know. Here's what should make you genuinely furious. This isn't rare. The average security deposit in the US runs between 1 and 2 months' rent. In major cities, that's $1,500 to $5,000 sitting in your landlord's bank account. Studies consistently show the majority of disputed deductions are for items that legally qualify as wear and tear. This isn't a few bad actors. It's a system that works because most people don't know the rules. And landlords who manage multiple properties have often built these deductions into their cash flow, counting on the statistical likelihood that you won't fight back. But now you do. Go back to that letter, the carpet cleaning, the repainting, the general restoration fee. You're not looking at your landlord's accounting anymore. You're looking at a negotiation, and you just found out you have leverage. Here's how you build it. Document everything on move-out day. Photos, timestamped, of every room. A written move-out checklist, signed by both parties if you can get it. Keep your original move-in inspection notes. That paper trail is what turns a demand letter from a guess into a case. Check your state deadline. Demand an itemized list. Challenge normal wear and tear in writing. Document the unit before you leave. 4 steps. That's the whole playbook. Because here's the final thing your landlord is hoping you forget. Small claims court exists specifically so people don't need lawyers to get their money back. It's designed for exactly this. You, them, a judge, your photos, their invoices. The hearing might take 45 minutes. The decision might take less. In states with penalty provisions, winning means they owe you more than they ever tried to keep. The whole system runs on one assumption, that you'll take the hit and walk away. One letter, written correctly, citing your state's actual law. That's usually enough to break that assumption entirely. So here's the question I'll leave you with. If a lease clause can be legally void the moment you sign it, what else in that document do you think is actually optional?